Thank you so much for coming. So we have today with us Ms. Usha Ramanathan, and many of you would know her from her articles in the newspapers, her appearances in the TV shows and all. And she has been at the front of a lot of civil liberties movement of late. The topic today she's going to talk about is Aadhaar and UID. And as many of you would know that Aadhaar, the judgment has already been reserved, and it is this one judgment which will have a profound impact on the Republic in the years to come. So she has been involved in both the Aadhaar litigation and the privacy litigation very closely, and we couldn't think of a better person to talk on this matter than her. So I'll invite ma'am for the talk. The format which we'll have is that ma'am will speak for about 50 minutes, 1 hour, depending upon her discretion, and then we'll leave the floor open for questions, yeah? Please, ma'am. Thank you.
What is this?
It's basically the screen, in case you have a phone.
Okay, I'm using it in some other form. Thank you very much for having me over. I think this is the first time that I'm actually going to be talking about the whole UID litigation. So I must confess that I'm not going to be calling it the Aadhaar litigation. There's a reason why I don't use the term Aadhaar, and I continue to call it UID. And that's because, and it's a story that I'm not going to tell you fully now, but it's because the term Aadhaar comes actually from private interest and not as a public resource. So I've written about it in different places, so I won't explain it here. So when I say UID, then you understand Aadhaar, yeah? So let it get translated while the sound waves are moving from me to you. The question is not just what happened in the UID litigation. The question is, why was a litigation even necessary? Why did we have to think in terms of a litigation in relation to a project that was brought in our midst saying that it's going to deal with corruption, it's going to deal with leakage, it's going to provide every poor person with an ID, and it's going to help the poor reach the benefits to which they are entitled. Why did such a project need even to be taken to court? And at what stage did this need for addressing it through the law and through the justice system, at what stage was that recognized? And what is it that led to that recognition? So maybe briefly I'll tell you about that in the beginning. Because when this project started, we knew about it as a people, we knew about it, we heard about it for the first time in 2009. And that was after the notification had been issued, which set up the UIDAI. Of course, soon after the notification, it's not like we knew about it. It took a few months before we got to hear about it because it slowly started moving into other spaces. And there were, in 2009 July, after Mr. Nandan Nilekani took over as the chairperson of the UIDAI, that's the time that he initiated a lot of conversations with various people, conversations with civil society, conversations with chief secretaries, chief ministers, within the government, and a range of players, bankers, oil marketing companies, a range of players. And it's during that time, therefore, that we first had these civil society interactions. The first one, I think, the first serious one that we all came to know about was held in the Indian Institute of Advanced Studies in Shimla, where some questions were raised about what a project like this would mean for privacy. And then the second one was held in National Law School in Bangalore, where law persons and persons from within the biometrics field were brought in together, with the idea being that we should all contribute to this project. But all of you are lawyers, you know that lawyers learn how to question. It's not like we doubt everything, but we want to understand it. And that's what happened at that meeting, except that we didn't get the answers that we thought we would get. So some of us have followed this project very closely from 2009. And by 2010, it was plain to us, early 2010, it was plain to some of us who had begun to track it and to watch it and to try and understand what this is about, it was plain to us that there were many things that were not being said which we needed to understand. And what was being said, what we were reading, did not inspire confidence. So I'll just give you one illustration of where the problem seemed to lie. In 2009, it was decided that the unique identification project would deduplicate the whole population on the basis of biometrics. So initially it was decided that it would be deduplicated on the basis of fingerprints. And the deduplication happens after enrollment. So there are 3 stages in this. The first stage is enrollment, then there's deduplication and issuing of the number, and the third stage is authentication. That is, you enroll, you get the number, but when you go to use that number in different places, you have to be able to authenticate yourself and say that this is me, to establish that this is me. Now, the third stage wasn't even begun in 2009-10, but the first stage was about enrollment and the second stage of deduplication and issuance of the number. In 2009 December, there was a report that was produced by a biometric standards committee that had been set up, which said that they had tried. They were only talking about fingerprints at that time because they hadn't decided on any other biometric. So they said that we tried this fingerprint on 25,000 people to enroll them, and we found that 2 to 5% of this 25,000 people did not have biometrics that worked. So that was our first indication that this is not some kind of a project where everything is known. And we also read in that they said, if you want, you can think of using another biometric along with this, so that you can get a better ratio of success in enrollment. And maybe you could think of iris, but that you need to do some studies before you do that. But we noticed that already interviews were being given, and a biometrics consultant was being invited to create protocols for running this project using fingerprint and iris. So it gave us pause, because we said, if we know nothing about it, how is it that it's being used over a whole population? And if we have to authenticate ourselves on the basis of our fingerprint and our iris, what does it mean? What are the implications of this? As an introduction to myself, I should say that my basic work has been on law and poverty, on the jurisprudence of law and poverty. So when I went into it, for instance, each one came from a different, from a different angle. For instance, J.T. D'Souza came in because he was a biometrics, he works in the area of biometrics, and there were things that were being said about biometrics which he found were inaccurate and wrong, and did not conform to the knowledge of the day. So different people came from different perspectives. I was thinking that, okay, if this is going to help the poor get an ID which they can use to reach their entitlement, it's not such a bad thing. But the first study showed, so it was in January, February of 2010 when they issued a notice to a biometrics consultant, where they said that actually we know nothing about whether biometrics can work in the developing world. Not only in India, but nowhere in the developing world has this been tried or tested. But we have confidence that it will work. I think all of us are votaries of confidence. Confidence is a very good thing. But you don't change whole systems across a population of 1.28 billion with just confidence. You need also to know that it will actually work. So that was the first signs that we had that there could be a problem. In the first document, the first strategy overview document that was produced, we found that it said that the poor don't have an ID, the poor will be given an ID through this, and they can reach their entitlement. It said 2 things. One, that although you are, it may help you reach your entitlements, it does not itself guarantee any entitlements. So that was the first thing where they said, you get the ID, and then it may help you reach it, but we can't guarantee any entitlements. The second thing they said was that enrollment will be voluntary, but if any agency makes it mandatory, then it will be mandatory. That's not our doing. Then you have to get on to this. And very soon after that, of course, we started watching how the UIDAI was going from department to department and had started asking them to adopt the UID as a necessary and mandatory field in their dispersal of various kinds of things. So whether it was kerosene, or it was PDS, or it was cooking gas, these were places where initially the push was started from here. Along with that, we also noticed that there was, in that same strategy overview document, it started talking about using it for financial purposes. Now, just using it for financial purposes is not a cause of great anxiety. But if you're going to use it as a determinative ID for the poor especially to get onto these systems, and it gets linked up with business interest, then we need to ask how much of equity is there and how much of certainty is there that the poor will not get excluded. So these concerns had already begun in early 2010. All of you are going to be lawyers of one kind or another, and I should tell you that lawyers turn out to be very important people in the whole civil liberties arena. You're extremely important. I don't think you have any idea how important you are. So it will be very useful if you were to recognize that importance now and do some of your learning in the process so that what you're doing is upholding the rights of people of this country. And when I say people of this country, I don't mean this class or that class, but across the board. The Constitution comes with many flaws maybe, but the Constitution is the one document that provides us with some basis on which we can negotiate with the state in terms of power. Power, the Constitution gives you a means by which you can negotiate power itself. So just to say this, that one of the early recognitions while working on this project was that the idea that the UID seemed to bring with it included certain kinds of things. For instance, what does the UID stand for? It stands for Unique Identification Project, right? It doesn't stand for a Unique Identity Project. It is for identification. So it is about someone being able to identify you. It is not about your being able to assert your identity. Now, this shift in power equation, where somebody will say, I am me, and if they don't say it, then I am not me, and I have to depend upon that system functioning, is a very different thing, from, for instance, from our having ID cards. We just show the ID card and say, this is me, and they can't deny it when they see that it is there. Of course, the ones who want to deny it can deny whatever they want, wherever, but it's still in your control. And that makes a huge difference to your relationship with both the document and the person who is asking for the document. So we noticed that it was called the Unique Identification Project. That was big. The second thing is, there is the term red herring, right? And we've met many red herrings in this. One of those was, we thought that when they said unique was about biometrics. That's what we thought. Didn't you also think that? That unique was about biometrics being unique, and therefore it's called the Unique Identification Project. That's what we thought for the longest time. So we thought that each of us is going to be uniquely identified, and we will uniquely continue to identify ourselves on the basis of biometrics that are unique to us. It is many years later, in fact it's only about a couple of years ago, that we realized that the unique is not attached to the idea of biometrics. It's attached to the idea of the number. So early in the project, there were 3 words that were used that became critical: unique, ubiquitous, and universal. So when they said ubiquitous, the idea was that this number that is given to you should be in every database. You have to make it ubiquitous. This is all part, everything I'm saying comes from various documents, and they don't come from writings that I did, and those are not documents. I'm talking about official documents. So the idea was that this is going to be ubiquitous, and because it will be ubiquitous, it will be possible to make it universal. Nobody can escape it. If you escape in one, if you don't need PDS, you may need your passport. If you don't need a passport, you may need a bank account. And in case you don't need it, we'll make sure that you can't function unless you have a bank account. So there are ways in which this ubiquity and universality was going to be achieved. And what was, when early in the project we found that biometrics doesn't seem to be a determinative, element for your identity, we wondered then why this project is depending so much on biometrics. It didn't make sense that you have a whole project that's going to run on biometrics, and then it's going to completely fail if biometrics don't work. And as we see has happened now, what the project was really running on issuing as many numbers as possible, and to do that, databasing everybody, And in 2011, there was a document called the Tag Up Committee Report. Tag Up standing for Technology Advisory Group on Unique Projects. And that has a whole other history which we can discuss some other time. But there is a part of that in chapter 6 of that document which says that, you know, what you need to do is it's garbage in and garbage out. So if you're going to hurry everyone onto a database, it's likely that this whole thing is going to be with a, you know, it will be filled with a lot of garbage. How do you clean it up? They call it a self-cleaning mechanism. The self-cleaning mechanism will happen because you won't be able to make your identity work unless you clean up the database as it is in the UIDAI's records. So if your information is wrongly reflected in the UIDAI's records, or if it is not wrongly, but if it is differently recorded from the way they accept it, then you will have to make sure that you clean it up. So the whole onus is placed on you. So early in the project, we recognized two things. One, that this is a project that puts an extraordinary responsibility on each individual to make sure that they get databased, that they are properly reflected on that database, or else they could become one of the three words that kept getting used through the project, which is fake, duplicate, or ghost. And you could take your pick which you wanted to be. Actually, you couldn't. Sometimes you were just called a duplicate, so you couldn't really take a pick. Now, this is one whole part of it. This is the way in which we entered into a constitutional thinking of this was saying that the relationship between the state and the citizen is mediated through the constitution. Now, the constitution is not about the power of the state over a people. The constitution is about the limits of power of the state over a people. So if it is about the limits of power, then the state can only exercise its power within the terms of the constitution, which means it has to respect fundamental rights, for instance. It can't say, it's okay, you don't need it. Or it can't say that, you know, I have a problem which I want to solve and therefore you give up your fundamental right. That right the state does not have. In fact, as we know, our constitutional law has developed to say, even if you say you don't want your fundamental right, you can't waive it. You may not exercise it, but you can't waive your fundamental right. That's how much we protect and preserve that. Now, in this project, from 2010 onwards, we had started seeing that that relationship was beginning to change. In 2011, for the first time, there was talk about making this whole exercise mandatory. That if you do not give your UID number, then you're not going to get LPG cooking gas. That was the starting point. That was the first experimental thing in September of 2011. It was like, you know, they threw it out to try and see what happens. They had to quickly pull back because there was a lot of pressure, you know, there was a lot of reaction from the public and from senior public who had the maximum trouble at that time with it, and also because they had not enrolled enough people, so they had to wait a little longer before they did that. But by 2011, we could see that the pressure would keep growing on people. By then, PDS, they were saying that we're going to bring it in. In Kot Qasim, they started with kerosene. You know, for you to get kerosene, you have to go and enroll for a UID. You have to get that number. You have to get a bank account. You have to put the UID number into the bank account. And this system the poor were being told that this is an efficient system that is making things easy for you. None of it matched up. It just didn't match at all. But the mandatoriness had begun. It was in 2012 that the first splash of mandatoriness came in our midst. End of 2012, you started having multiple advertisements which came from the center, which came from state governments, saying that if you do not give your UID number, you're going to lose A, B, C, D services, a large number of services. So in Delhi, for instance, the Revenue Department issued a circular saying that you will not, anything that goes through the Revenue Department, you will not get unless you give your UID number. So what does that include? It includes caste certificate, it includes domicile certificate, it includes anything that you might want to have to do with the sub-registrar's office, which means if I want to register a will, I can't do it unless I'm going to have the UID number with it and everybody has it. If I want to get married, I can't. I mean, I can't anyway, but there are others who could, and they can't. So everything started depending upon your having a UID number, which you would then put into these systems. Now go back and look at what's been happening and see where biometrics got used. Biometrics have been used primarily in PDS. They've been used for NREGA wages. They've been used for the poor to be able to operate and get themselves their money from, from banking correspondence. They've not been used where the rest of us, for instance, if you have to attach it to your PAN card, they've not asked you to use your biometric. They just put your number. So everywhere you've had to use your number and put your number everywhere. So the number had to be ubiquitous and it had to be everywhere. This started in 2012 and that splash brought in multiple concerns. So actually Justice Puttaswamy was not the first person to go to court, but he was the first person to go to court in the Supreme Court. There were others who had filed cases in different places and they were challenging different elements of this. For instance, in Chandigarh, you'd had a case where they had, for driving license, they said without a UID, we won't give you a driving license. So that was challenged in the Punjab and Haryana High Court and they said, no, you can't. Basically, the administration came and said, okay, we won't push this. So they pulled back on it. You'd had this happening in multiple places, but Justice Puttaswamy for the first time took the issue to the Supreme Court. When he took it to court, there were three issues that he raised. One, he said, how can you have a project of this dimension without a law? Now this is important because he said it in 2012. And just to go back briefly and tell you about the status of the law on this, when they started the project in 2009 January, there was no law. And if you look at the documents that preceded this, every document acknowledged that privacy is a problem and we will need a law, but they said some other time. Let's start now. When you read the Sri Krishna Committee white paper, you'll find that there too they say innovation there should be no barrier of law. It shouldn't come as an obstacle to innovation. So law is seen as an obstacle, not as a protection of people's rights. So you do the innovation, you do whatever you want, and at the end of that, you make a law to fit it. So you don't make a law to protect people's rights, you make a law to protect the project that has been brought in. So you find a similar kind of anxiety that you find here. Now, by 2010, civil society had started getting active, and they were constrained to bring a law in the Rajya Sabha. They were not constrained to bring it in the Rajya Sabha, but it was brought in the Rajya Sabha. And that law was then referred to a standing committee of parliament. And because this was located in the planning commission, it went to the standing committee of parliamentary standing committee on finance. Now this committee examined it. In fact, in July of 2011, some of us appeared before the standing committee. And at that time, they were telling us, they said, yes, madam, we understand what you're saying, but we can't ask for this project to be scrapped. We can tweak it a little bit here and there if you want. How can, such a big project, how can we ask it to be scrapped? At that time, they had only heard a few people. And then between July and December, when they gave their report, a large number of documents went to them, and that's the time that they perused all those documents and looked at what there was. Many of us were very surprised at the stridency with which the Parliamentary Standing Committee rejected not just the bill, but they also rejected the project. They said, you cannot have a project like this in our midst. You haven't even had parliamentary discussion on how biometrics should be used. You're having it proliferate all over the place. You've not taken into account the cost that's involved. You've not worried about what companies are holding our data. You've not worried about what happens to privacy. So none of the things that needed to be considered have been considered. Parliamentary Standing Committee was also furious because they said, you started the project even before you brought in the law. And then you come to us and tell us to pass a law. What kind of process is that? This is disrespect for the parliamentary process. And then they had also said that this is a project that doesn't make a distinction between a citizen and a non-citizen, and therefore for illegal migrants. Now, when we say illegal migrants, I want to pause there again. I'll be pausing in many places and leaving them unfinished, so it doesn't really matter. You can come back to it whenever you want. This project has found different justifications at different points in time. So after the Kargil war, they said, oh, infiltration from Pakistan. That was the problem. By 2003, 2004, when they amended the Citizenship Act, it was no longer about infiltration from Pakistan. They were saying, oh, Bangladeshi migrants. So that is our biggest problem. All these are red herrings that go along with the project. And it's an idea that they give to the people of this country that, you know what, all that should go to you is going to people who don't deserve to get this. So then everybody rises and says, yes, yes, everyone should have it, so that the Bangladeshi illegal migrant can be found. So it's a way of marketing a project, it's not a way of resolving an issue. In any event, this project at no point concerned itself about the citizen. It was supposed to, in the beginning, when it was supposed to be linked up with the National Population Register. The National Population Register has in multiple kinds of ways. You will see what's happening in Assam now and the kind of complications that have come there. You'll see what has happened in terms of the shutting down of that project over a period of time. You'll see that the UIDAI, after having started piggybacking on the National Population Project, then goes off on its own and then takes over everything and finally tells the National Population Register and the Registrar General of India that we are not giving you biometrics because, that's not permitted by the law. So you can deal with your own problems. We are not going to assist you. So from being a back office, they become the institution that's going to throw the national population out of the reckoning. Now, I will say at this point that I am no votary, I'm no fan of the National Population Register because I really think citizenship is an extremely complex and political issue. It's being reduced into an administrative process, which I do not agree with. I also think that anywhere in the world, we should not be denying people basic requirements like food and shelter. It doesn't matter whether they are illegal, legal, whatever. It's essential part of human rights that no one should be denied this. We say that this is true when it comes to people who commit heinous crimes. Why do we think an economic migrant should not be treated with at least that much concern? So I'm just making my position clear on this, that I don't think that that is an argument that should be used anywhere. In any event, when Justice Puttaswamy went to court, after that first thing on the law, because the law had been rejected in December 2011, and they never brought it back. See, the Parliamentary Standing Committee only has a recommendatory role. It doesn't have any means of controlling what the legislation will be. Not only did they not adopt what the Parliamentary Standing Committee had said, they just ignored it and carried on without a law. That's what they wanted in the first place, so it became easy. And you find that till 2016 March, no law was passed. And I'm going to jump a bit just to say this, that in 2016 March when it was passed, we all know it was passed as a money bill, so that there would be no discussion that can make a difference to that law. Because there was a majority in the Lok Sabha and therefore it was passed as a money bill. That's also pending decision before the Supreme Court now. At that time in 2012, when the case came to court, the problem was that there was no law, not that there was a law that had been passed unconstitutionally. The second thing that he talked about was, first, that there is no law. The second, that privacy will be impacted. So he said, this is a project that's going to affect people's privacy. How can you carry on without even considering what those implications are? How can you have a project like this? And the third thing that he brought on board was that illegal migrants are also going to be given these UID numbers. They'll also be enrolled, and therefore, what is the validity of this? In 2013, by 2013, there were many people across the country who had been watching this process with a lot of anxiety, especially people who work among the people, who found that they could quickly see that this was becoming one more layer which could quickly become an obstacle for people being able to realize their rights. If you look at what happened with the right to food, for instance, you'll find that in the early 2000s, the right to food and PDS system had really it had become so leaky that people were not getting what their entitlements were. That's about the time, from about 2003, 4, 5, you find that the debate goes on where the Planning Commission is saying that they want to give targeted delivery of food, and the groups are saying, don't do this, because the moment you say targeted delivery, there are all kinds of problems that come with it. Make it universal. And people will opt themselves out when they don't require it. So you don't really need, because this is a country where even now about 67% of the population has to be covered by PDS. So we are a country with a large number of people who require the support of the state. So there is no need for us to narrow it down ourselves and shrink it. This debate had been going on. In the meantime, the right to food people had been working on shoring up the system. So there had been a lot of work that had been done between people on the field and the states, and there had been many changes, and the classic ones, of course, which are always held out and which are very interesting examples, are Chhattisgarh and Tamil Nadu. But even in the worst states, by about 2007-8, they'd started reducing leakages in a huge way. As far as NREGA was concerned, they were saying that, oh, you know, everybody, the middleman takes the money and goes away. But actually, by 2008, the figure is something like 87% of all NREGA workers already had a bank account, and the money was being put into the bank account. So it's not like somebody was just siphoning it off in the middle and walking off. So what we had realized by then was that the problem with this project is that it had created something which it was saying was a solution. And then it was trying to find the different problems which would justify this solution. And those were creating problems of their own in turn. So what was being projected as a solution was actually becoming a problem. So in 2013, you find that number of people come to court. So there are people who come in saying that exclusion is the primary problem. There were a number of issues that were brought in. There was exclusion of people who will not be able to authenticate themselves, who will not be able to enroll themselves, who won't be able to operate the system, new middlemen who are being created like banking correspondents, they'll have to depend on them. So there were a range of things like that. Mandatoriness itself becoming a means by which exclusion happens. Then there were others who were saying, and many of them overlapped, of course, that there is a problem of surveillance, that surveillance, tracking, profiling, all this becomes very easily when you start databasing populations. Then there was a question of personal security. It was not only, when we say privacy, privacy is far vaster than just my neighbor knowing about me. I mean, this is not about gossip, it's about personal security. So there was this great anxiety that if you're going to allow people who already have a lot of power to be able to converge data about me, then you're creating a system that is going to result in personal security issues for me. There were issues of national security. Because if you create these databases, that's around the time that people started saying that, around the world, not just here, that you can't use the word electronic and secure in one sentence. Anything that's electronic, you can't guarantee its security. So why would you want to collect and aggregate and keep all data about a whole population on a database that somebody can enter and take away from? By now we know that you don't even have to enter it. It's not even about what is on the UID database. It is about what the number allows to be linked and converged as information in multiple databases. So even then it was being said that even then there were many silos of information. You gave your information to multiple silos. You gave it to your bank, you gave it to your college, you gave it when you went to the hospital, but they remained in silos. The UID number became the bridge between all these silos. The moment you put that number there, it becomes a bridge between all these silos. And that is not a good idea. That bridge between the silo is also reflected in the authentication records of the UID AI. Every time you put your number in somewhere or you put a biometric and it is verified against the UID AI database, that retains a record. So it knows where you have your account, it knows which hospital you went to. The whole ecology of your life is revealed to it, even if it does not have detailed information about what is in those records. So the UID AI doesn't have health records, but the UID AI creates access to those health records with ease. So in 2008, just before this started, there were two other institutions that also began. One is called the National Payments Corporation of India. And it's important to know about it. I'm not going to say too much because it will take us too far away from this. But it's a very important institution to understand. Under the TAG-UP report, they say that there will be many institutions where government data will be handed over to private companies. And government functions too then get handed over. And they will then be called, these private companies will be set up to handle this data. They will be natural monopolies. And they will be called national information utilities. Now, this is a use of language where it obfuscates for us what actually is. When you call it a national information utility, you think it's government. And we do have a certain fiduciary relationship. We are in a fiduciary relationship with the state. So, for many of us who worked with the state very closely, even when we have different positions from the state, we are talking to the state all the time. We've been on government committees trying to help make policy. So our engagement has a lot of the time been with the state. But you find that this takes it to a completely different level. The other thing that you find over time is that the first stage is the creation of this database where you have all these numbers. The second stage is what is called creating a platform. So somebody like Mr. Nilekani will always be saying, oh, it's identity, okay, but it's actually what we are doing is creating an identity platform on which many apps may be built. And the third stage is where businesses actually start operating on the basis of this database. And on the basis of what this number starts to reveal in multiple other databases. So this is one kind of thing, and the NPCI has become one of those which adopted the number. So there is the NPCI, and Mr. Narayan Murthy was the chairperson, first chairperson, and Mr. Nilekani is the UIDAI chairperson. He's been the honorary advisor to the NPCI throughout on the adoption of the UID number for all our money transactions moving. Very recently, there was a circular out saying that the NPCI has told banks that money will not move to UID numbers but to bank account numbers. There is a whole story behind that statement. It's suspense now, I'm not going to tell you. We'll talk about that another time. But the other institution that was set up in 2008 December is called the National Intelligence Grid. Now this National Intelligence Grid was set up, and as it was said to us, it was set up saying that from 21 databases of various kinds, whether it's your travel or your money or your health or your whatever, from 21 databases, there will be real-time information that can be given to 11 security agencies, security and intelligence agencies. It's important for us to remember that ours is one of the few countries where intelligence and security agencies, many of them are not under any law. There is no supervision from anywhere. Many of them are just under the Home Ministry. That's it. So and they are all outside the ambit of the RTI. So that's the kind of structure into which they were saying they were going to give it. How are they going to create this real-time information from 21 databases? The UID becomes the connecting agent, putting the number everywhere, ubiquity. So all these went in, so surveillance. Then there were companies that had been brought in. So even in the last litigation that happened in the court on the UID matter, the CEO of the UIDAI was making a presentation. And actually this again is a historic thing for that too, because the first time I think the court has been given an argument in a PowerPoint, of a PowerPoint presentation. So there was really no argument, it was presentation of the project and not of the PowerPoint itself. Now I have no idea why I said this, so I'm going to carry on with the next. So there was, and then untested biometrics, inversion of the relationship between the state and the people. That was the overarching thing, that there is this inversion of relationship that's happening between the state and the people. Now, in 2013, all of you have heard of Edward Snowden? Yeah? So Snowden, in June of 2013, makes his revelations. And it comes out, and everybody knows then how databases are being used and what is the extent of interest of the National Security Agency in people around the world. It's a very interesting juxtaposition. You find the Indian state saying that we are not asking anything of, you say you will give your information to American visa authorities and UK authorities. Give it to your own state. Why will you not allow your own state to see you clearly? And in the US, when the Snowden revelations happened, the American establishment was saying, we don't surveil Americans. It's only everybody else. So the way in which you think about your own people, this project told us that many of us are people who worked through various kinds of issues over the years, and you know that minerals, for instance, are seen as belonging with the state. So they say it's under the land, it's not yours, it belongs to the state. Then rivers, streams, lakes, all of them, they say it's under the control of the state. So that whether it's a public trust doctrine or not, it's something that the state says it has control over. Then you find that land becomes something that they say that they have control over, and there is a whole land acquisition debate that has gone on. With this project, they've started saying that you and what you are and what you have to act in accordance with what we say because it is ours. It's the state's. You belong to the state. And when we tell you that we want your biometrics, you have to give your biometrics. When we tell you that you have to attach your number to the bank account and you don't, I will take your money away. So there are various ways in which, just think about what this means and think about the various situations that have come up in the past, say, 7-8 years. and see what this assertion of power over a people and the idea of ownership and of property in a people has emerged in this time. Now, this is completely contradictory to a constitutional fundamental rights position. These two can't coexist. The state can't say it owns you, and therefore you have to give up whatever it wants you to give up, and also say that constitutional fundamental rights exist. Both can't exist. So that's what the battle was in the courtroom. So after Snowden, the strange thing in our situation, and that's something that as lawyers you need to think about too, is that nothing changed. Snowden told us what he did. We saw Citizen 4, we saw the film on him, and then we carried on with our lives. There's something wrong when we don't get what is happening to us. So I think we need a little bit to think about what that is. In 2013, the court starts giving interim orders. It's not like the court was making some great radical statement. The first time they gave an order was on the 23rd of September, 2013. And they said what the government was telling them. They did not make an order beyond that. The government was telling them, no, why are they saying all this? It is not mandatory. This is not mandatory at all, it's voluntary. Then they also said, no, we are not giving it to illegal migrants and things. We are only giving it to our own people, to residents who are here, because we need to be able to make our system smoother. So the court said, okay, that's what these people also want, so we will record that nobody should be denied any benefit, any entitlement, merely because they don't have they called it the Aadhaar card. There is no such thing as the Aadhaar card, but whatever. So they said that the Aadhaar card. Immediately the government counsel jumped up and said, please don't say that. So the court was actually confused. The court was saying, but you said that it's not mandatory. And they said, yes, but don't say that in your order. So it was plain by then that it was intended to be made mandatory while saying that it is voluntary. They didn't want the court to come in the way of that. But as we know by now, the court does not come in the way of projects of this kind. The court can say whatever it wants, the government will do what it wants. So from then, systematically, 6 orders have been passed before the other hearing started. And in each of those orders, they would go one step further. So in September, they gave this order. Immediately, the UIDAI, oil marketing companies, a few others went to the court and said, no, please allow us to make it mandatory. After saying it's not mandatory, so this is all on record. They said, allow us to make it mandatory. The court did not entertain it, and they said interim orders will continue. Then they went on. The next time it came up before the court in 2014 March in another case, which was between the UIDAI and CBI, which is another story again. The UIDAI, the court said, listen, you're not listening to us, so you've got to change all the forms and circulars that you have to make it plain that you do not have to have a UID number. Nothing was done. 2015 March, they did it again. 2015 August, finally, when they said, okay, we are going to hear the matter fully, the government came before the court and said, the people of this country don't have a right to privacy. That was actually an extremely useful moment. Because in a case where, when you go as a public interest petitioner before a case and the other side is the government, there is going to be a presumption that the government is acting in good faith. I too would do that. I wouldn't want to see bad faith in the state. So if somebody is coming before me and saying that, the government is acting in bad faith or they're doing something that is destructive of people's rights, I'll want the person to establish it before me. In this case, even as the petitioners were beginning to establish the case, the government did the job for the petitioners. They went there and said, and this is extraordinary for a government to go, see, the government's job is to respect, protect, and fulfill fundamental rights. When that government goes before a court and says, the people of this country do not have that right at all, it's extraordinary. It's not something that happens every day, fortunately. Yeah? So that is something, that moment was a significant constitutional moment. I know that we think of the privacy judgment as having been an extraordinary moment in constitutional history, but I think the moment when the government went and said it is not there has as much extraordinariness as anything else. So we need to understand why such a thing would happen. And I know I've said this before in many places, but I'll just say it one more time, that it's important that the government was saying this only in relation to the UID litigation. Down the corridor, in another case where petitioners had gone asking to strike down Section 499 on defamation in the Indian Penal Code, the government was there representing that please do not strike down Section 499 because people of this country have a fundamental right to privacy and we have to protect that right. And this is the route through which we can do it, by having a criminal law where we can come in and we can protect that right. So it is significant that this, you can, some people say it was a strategy, it was a tactic to put off the hearing. The fact is that between the time, that is August 11th, 2015, and the time that the case started getting heard, no government took any other position. The only time that they did it was done when, I think Mr. Jaitley in Parliament, when the bill was introduced, he said that we've made this bill on the assumption, accepting that privacy is a constitutional right. It's a fundamental right. Now that didn't change their position in the court. So it's a very, very significant thing that happened, and it's something that we have to watch for, because constitutions are protected by people. They are not protected by courts. Courts help us, but we have to help courts help us. So we have to recognize what that is for ourselves. So that's one stage of what happened. And then there was a slight widening out of that happened in, where, because when they did this and they walked into court, you could see that the judges were upset by this. And the judges said, initially actually they started with saying, we're going to suspend the 2009 notification, which meant nothing could happen after that. Then the Attorney General said, no, but the poor of this country don't have. Actually, this is again another myth, because their own, through RTI and in the court papers, they've admitted that not more than 0.3% of the people who had enrolled when 80 crore people had been given the UID number, only 0.3% had needed an introducer, which means that they were able to bring their own identity to the system without any help from anywhere else. So this is, there are many myths that have been created in this process. In 2017, right in the beginning, in January, you had the court being approached and told that, listen, you've said urgent many times, but you're not constituting the bench. And the August 11th bench had merely said a larger bench. You didn't know whether it meant, should it be larger than the MP Sharma bench, which is 8, or should it be larger than what? So the judge had to decide that. And it was also possible that you could just have 5 judges who could then have held that this question of privacy doesn't arise, and therefore you don't even need a larger bench. But anyway, at that time, the Chief Justice said, I don't have enough judges to give you, because you would need 9 judges, presumably at that time they thought it could be 9. And there weren't enough, the appointments hadn't been made, they didn't have sufficient number of judges. But unfortunately, in 2017 February, there was a case that an organization that represents itself as a public interest organization called Lokniti, they went to the court and said, terrorists are getting mobile phones. They'd gone already and said, terrorists are getting SIM cards. What is the government doing to stop it? Now, I'm not sure that this is the way public interest petitions are supposed to be agitated at all, but in any event, they did go to court. And the really unfortunate thing is that the Attorney General, who had been there in October of 2015, where the TRAI had made a representation there saying that, listen, we want to use it to stop antisocial elements from being able to get from being able to get SIM cards, so we want to use the UID number with it. There, a 5-judge bench had turned down that plea. They had said, no, no question, and they just limited it to 4 other areas. They had not allowed for the mobile phone linking to be done with the UID. The Attorney General in February 2017, it was the same Attorney General, but he went before the court, made a statement that they were going to verify every SIM card with the UID, did not tell the court that a 5-judge bench had refused this prayer. The court then records it saying that this is what they are saying they are going to do. So if it gets taken care of, fine. The court does not direct the government to use this UID system. Then after the order of the court, further misrepresentation is deliberately done, where they say that, oh, the court has ordered that we should verify everyone and everyone should link it. So it is a web of, I can't put it more politely, so I have to say it. It's a web of lies and deceit. And that is really not acceptable in any kind of constitutional system. This is the worst kind of contempt of court. And the only reason that no contempt action has happened is because the court, as far as is possible, respects the government because it is another equal partner or another equal player in what is happening in this state. So they will not do it unless they are really pushed. For us, that moment had already happened. But for the court, what they did do, however, was that in July of that year, suddenly it was decided, it was whatever happened in court happened. I mean, it's like a drama, so you have to write it out like a script. And the Chief Justice said, okay, tomorrow I'm giving you a bench. Now, this is where the lawyers come in. The lawyers were unbelievable. So from 2010 onwards, we've been talking to a range of lawyers and just keeping them informed about what is happening in this project, because it was plain that this was a project that was going to have constitutional implications. So different lawyers had been primed over a period of time, and I must give it to them, the very busy lawyers with huge practices who make, who really charge the earth from people, gave us time through those years to go and brief them on what it was without even knowing why they should be hearing this. Only because we were saying, someday we may need your help. So when the privacy case actually came up, there were a whole batch of lawyers who were ready, who knew what this matter was about, and who knew what the implications of this was. It was extraordinary because there were actually just 6 days when the hearing happened. It happened within a week. And within that time, they were given very little time. So they had to quickly, and extraordinary coordination between the lawyers too, because they didn't want to overlap what each other was saying. So they accepted different kinds of briefs for that representation. And every one of them put in huge written statements so that it is there on record about what has been said on privacy. And if you look at the judgment and you look at the written submissions, you'll find that a lot of it was picked up from there. So all that help that they put in worked, and all this done within a period of 6 days. All this done pro bono. All this done with them working all night, their offices working all night, not just not charging, but actually spending money on it. And senior lawyers sitting in the court listening to other people's arguments. It doesn't usually happen. Usually you'll have a junior who'll sit there and take notes and then hand over the information. Here, so when we asked those lawyers and they said, why are you doing this? Why are you giving away all your other cases and sitting here and listening to these matters? The answer we got was actually profound, and we are deeply appreciative that they saw it the way they did. The answer we got was that if we lose this case, there is no constitution left. That's for the lawyers. So one day you should be able to thumb for yourselves like this. It's so important to protect the constitution. And each one of them, it was outstanding. And I really, if any of you had been there and heard it, you would have known the quality of lawyering that happened at that time. So, and you know what the judgment was. And the judgment was an extraordinary judgment. We also know that when the argument started, the lawyers were told that this is not an argument on the UID project. This is an argument on privacy, so just address that. However, there are 2 paragraphs which were slipped into the judgment, which 4 of them have signed on to, which was not argued. But broadly, they've said that, for instance, siphoning off resources can be a legitimate state aim. Now, where they got that from, I don't know. But they got it, they've put it in. The good thing is that in matters like privacy and in matters like many fundamental rights, cases have to be decided case by case, which means they have to hear what that case is about. So I'll come to the last part of what I'm going to tell you, which is the last set of hearings that happened. Here too, you'll find, and it's one of the few times that I have seen at least, senior lawyers who would call up and say, listen, if you have a brief and you need someone to argue, let me know. And they would just do it. There would be no questions, no nothing. They would spend weekends just reading the whole thing up. No competition among lawyers, maybe a little bit briefly here and there, but hardly at all. Nothing that could derail the litigation. And it was an offer that was made because there were more and more people who were seeing that this project was a problem. When we started on this, we were just a handful of people. And over a period of time, as people started reading the documents, see, this has been our problem all along. We couldn't get administrators to read the documents. When we would go and tell them, say secretaries, and tell them, please read, there is this strategy overview document. There is this micro ATMs and UID document. Just read it. PDS and UID. Read the document. You'll know what it's saying. They would say, oh, madam, we already seen the PowerPoint. PowerPoint does not give you. PowerPoint is a marketing tool. Even for ideas, it markets ideas. It doesn't really give you what it ought to give. So it was the hardest thing for us. But here you had lawyers, as they got into it. I remember when I was trying at one time to get people to write, and I would send off documents to them. There was one person, one Ravi Shukla, who had written an article where he had said it might help the market right in the beginning, in 2010, 2011. And then I thought, we need somebody to write for the project too, because we want to hear, we want to know what the different positions are. So I sent him the documents and I said, will you please do a piece for EPW or something so that we know what you're saying. He wrote an article which completely trashed the project. Then I called him up and said, listen, I asked you to write so that we'll know what the positives of the project are. He said, yeah, before I read the papers, I thought they were positives, but after reading them, I don't see it. So it's been a kind of, you have to educate yourself through the documents and through watching what is happening. As this case moved into the final phase, we started hearing about the deaths. This is something that was anticipated. We'd been saying that a project of this kind will mean genocidal impact on the poor. The poor cannot navigate a system of this kind. When you look at PDS, you find that first people have to go and enroll. After they've enrolled, they have to take the number, go to the dealer, and then link it up. After you've linked it, every month you have to go and your biometric has to work. For many people, each of these stages was difficult. So you find, for instance, that the first death that was recognized as a starvation death and that was seen as having a connection with the UID project was found that they had the UID number. They just hadn't managed to link it. Whatever, really poor, if somebody died because they did not have the PDS grain, it shows you the level of poverty. And we were asking them to navigate a system and putting further barriers. So what was being asked was that don't make this the process through which, your actually deaths have started happening. So stop doing this. Then you find that one after another, at least between 13 and 15 deaths are now recognized, of which at least 7 are clearly linked with the UID. The others, there is contestation. In fact, one of the most tragic moments in this whole episode was where, after a death, the Jharkhand government said that they were setting up a committee to define hunger deaths, to define starvation. I'm not sure that's where the priority should have been. But anyway, that's what they decided to do. So all this has been happening, and then the petitioners start their arguments on the 17th of January 2018 before the court. Initially, the court is a little, because there were a lot of lawyers, the issues were obviously a lot, and the court is feeling a lot of pressure because there are a lot of constitutional matters that they need to deal with. So there was an impatience in the court in the beginning and also an outburst in the beginning, after which the outburst stopped and they started hearing, but while limiting the time. You could see that they were listening, but they knew that they would get there. After all, in a court, this was an adversarial litigation. It was filed as a PIL, but it was it was an adversarial litigation. So for the government, for the court, the best way to know what the answer to what the petitioners are saying is what the other side says, which is the government and whoever is supporting the government on this. And I must confess that one part of me has followed this project and said, how on earth can we allow a project like this to say? The other part of me has a little academic element in it, and I'm like, okay, I want to know what they're going to say, because there could be some interesting thing which I've missed. So, and the problem in this system is also that all the petitioners will speak, then you come to what the government says. So, which means that, you have to wait. You don't know what you're addressing. You don't know how it's going to be addressed. When ultimately the government spoke, I have to say that for me at least, and you can go and, since everything was tweeted, you can take a look at all those tweets and see if you can find any argument that was placed. See, one of the things that was being used to push this project and to say that it's great is to say that the savings had been huge. That a lot of savings had been made because the UID had been linked to this. When they said that the savings on LPG had been huge, the CAG actually went into it and found that the extent to which the UID could have contributed They were saying it was some 24,000 crores, 22,000 crores to 24,000 crores, had been saved with the UID. They were saying that the CAG said no, actually a large part of it had already happened because of digitization. A much larger part had happened because of the fall in oil prices worldwide. And if there was anything, it was maybe 17,793 crores. Where is 22,000 crores and where is 1793 crores? If there was anything, because there could have been a multiple other set of reasons why this happened. Deduplication had already been taken care of by digitization. You didn't really need to go through this process. So that was one set. Then you found that in Jharkhand, when the death started happening and you asked, okay, how many people got excluded? What was the feedback loop when you excluded people? They said they had cancelled 11.5 lakh ration cards. They didn't say why, how, but in many of those cases, it was because there was no link with the UID. Now, if there is no link with the UID, it doesn't mean you're not a person who's entitled to ration. It just means there is no link to the UID, that's all. When we asked, is there any feedback loop? Did you then, having got these 11.5 lakh, was there some system of either social audit or anything else by which you went back to the field and you found out whether these people are actually there, whether they are actually duplicates, why did they not enroll? There was no system. It was just technological determinism. If you have not linked, then you are a fake. So 11.5, which means something like 60 lakh people had been excluded without any kind of process. And some of them had begun to die. And this is in a state where we know that there is a high tribal population, where we know malnutrition is high, and where the PDS is like a lifeline for many people. So all this had already started happening. We were looking actually, and the savings therefore was to discredit it, because if you're saying I'm cutting out people because they did not link their UID number, that doesn't mean you took out fakes. It just means you took out people who did not link it up. So none of that added up, and actually in the argument, the savings argument was not pressed at all. So what argument did get made? I have tried looking. I've looked, I've read those documents again and again. I've looked at it again and again. I don't know that any serious argument seriously got made. And that worries me. I am opposed to the project. I do think that this project should go for multiple reasons, which I'm not going into all of it now. But it does worry me that a government was willing to go along with a project like this without knowing what the purpose of this project was, which they could then tell the court. You can't keep saying corruption, terrorism, all the problems that we have, we can keep saying, and then say that it will solve all these problems. It's not solving any of these problems. So what is it that was done that has made all of us data-based? So I'll end with this now, that when the law finally came, it came with a provision in it, which is Section 56. Section 56 is the provision that allows for private individuals, private companies, whoever else, to use this database for their businesses. This is the place where you say that this is not about identity, it's about an identity platform on which many apps may be built. So this is the businesses that were going to be built on it. While the case was going on, 5 such entities asked to intervene in the case and came to court. Of those, one was the Digital Lenders Association, another was a company that deals with blue-collar workers. The third was a company that said that its business was being a eKYC service agency for the UIDAI. And they came to the court and they said that please do not change anything in the law, do not change anything in the project, or our businesses will collapse. And the link between business and government in this project is extraordinary. You'll find that there is, this is one project where Mr. Nilekani is brought from Infosys, he enters the government, he has cabinet rank without cabinet minister's responsibility, and the policies are made by extra political parliamentary agencies. So this is, where we've always had business negotiating, lobbying with the state, and we become the other side and, a lot of negotiation happens. But when they enter the government and become part of the government to make decisions that affect us, it's a very different story. The story, however, took a different turn because you have a thing called India Stack, and you might just want to read up a little on this. Now, India Stack was created, it is a stack of applications. So e-sign, eKYC, DigiLocker, all these are being created by technologists, and then in their own language, it's being evangelized to the state so that their businesses can be built on it. So NPCI, GSTN, algorithms, AI, all these are the wider vision of why you have something called the UIDAI. Yesterday I was traveling with a person who said, no, I think this project, because he said the project is fine without having read a single document, like most other people. But he was kind of honest to it. He was not doing it because he had any personal interest in it. And when I asked him, why do you think that this is a good project? What do you think, what purpose do you see it as serving? He said, well, payment banks and the payment wallets are able to quickly authenticate their customers, and it's become cheap for them. So I asked him, do you think that that is a sufficient reason to database a whole population, to bring in problems about, for instance, the national health stack? And I'm just going to read one line from that for you, where they say that the national health stack, it will potentially place India at the forefront of medical research in the world. The design is geared to generate vast amounts of data, resulting in some of the largest health databases. This is about each of us, with secured, anonymized, aggregated data. So you use all those words and then you say, of course, we can't encrypt sufficiently. The point is that when they say data protection today, they are not talking about some amorphous data. They are talking about personally identifiable information. We have become the product. We have become what we have, information about us. So it's actually being given to us now as trickle-up theory. Have you heard of trickle-down theory? Yeah, so you create a huge pie and something will trickle down even to the last person. That didn't work. So they are saying, let's do trickle-up theory. What is trickle-up theory? There are many people in this country who have nothing to offer the market. But they have something which the market wants, which business wants. What is that? Data about yourselves. This data will trickle up. So for it to trickle up, what do you have to do? You have to leave digital footprints everywhere. So this is the kind of ambition that is driving a project of this kind. This is the basis of that ambition. And most recently, you have this ambition showing itself in what is called the BESIL tender. I don't know if you've heard about this. You may have read about it in the papers recently, where the court is also getting concerned, where the government has advertised and said that they want they want companies to apply because they want them to do a certain set of activities, which is monitoring the social media, because they want to do perception analysis so that they can find out what people are thinking about what the government programs are and how therefore the government needs to convince them that the government programs are good. So it's basically, and they want to do leadership analysis, that is who's leading thought, who are these people who are leaders in thought. So this kind of ambition of knowing a people too intimately is an anti-democratic ambition. How many of you want to be known so intimately by anybody at all? And sometimes I don't even want to know myself that well. So the idea that perception analysis can be a way through which, now you've seen Cambridge Analytica, you know what that means. Except that this will be under the power of the state. And they are talking about setting up this agency inside the Information and Broadcasting Ministry, where they will be generating reports on what people are saying in social media, about who's saying it, and all the rest of it. In social media, they also included email, I don't know how, but whatever. Anyway, now there is another interesting element in this, and that's where I'll stop. Because what is the point of all these litigations? Will this litigation only have to do with UID, whether it is, I often get asked, what do you think will happen in the case? And honestly, I have no idea. But when I think about what Parliament did, where the parliamentarians started with saying, it's okay, and then they read the papers, and then they said, oh, maybe it's not okay. I'm hopeful because this is a court that reads papers. That I can completely see. Even with the privacy judgment, you could see that they read the papers. So if they read it, what they will come up with, I don't know. But this much is very plain, and I have no idea what I was going to say, so I'm going to say something else. that the kind of ambition that the state is showing now is an ambition that business has shown, Cambridge Analytica has shown, Facebook has shown. In WhatsApp, they are now asking that different systems should be used. Google wants to enter. See, this is a time when all these agencies are involved with these projects. But unlike earlier times when industry would be involved in the work that they are doing, if I am a steel manufacturer, I will be manufacturing steel. I might create environmental problems, but you're dealing with me, dealing with steel, right? Today, all of these kind of technologies and the uses of technology and the use of artificial intelligence and of algorithms, all of this means that they are moving beyond their business into other businesses. So they want to get into health predictive work. And the really last thing that I'm going to say is that there is a bill that is that's being introduced in the Rajya Sabha. I don't know whether it's already happened today or it's going to happen tomorrow, which is called the DNA Use and Regulation Bill. There's a whole story that's gone behind that. Another case of databasing, another case of a lawless state where it can't wait for its own committee to give the report on data, on data protection before it creates another database. So we are now confronted with having to protect our rights and also having to train a state to become lawful again. This project has shown us the extent of lawlessness of the state and of its contempt of the court's orders, its contempt of the constitution where it is producing things as money bills, and its violation of orders resulting in various kinds of threats to us. In the income tax, they've told us now, the income tax department says, okay, it is true that last year you had an order where they said those who have not already enrolled for a UID do not have to give their UID number when you file income tax. But each of you now need to go to the court and get a judicial order to say that you should be exempt. Yesterday, the Delhi High Court has changed that and said that CBDT must change their system so that people, you can opt out of the UID. After all this time, finally we have that order yesterday from the court. So the courts are now also being told that it's time for them again to become protectors of people's rights. But the courts can't do it unless we recognize our rights and we start asking for it. We are not asking anybody else, we are asking ourselves for it. The other thing that I learned through this process was that they keep saying that we are an anarchic people. We are too many people and therefore there's anarchy. If there is one thing that this project has shown to us, it is that we don't have enough anarchy. So I would request you as constitutional citizens to protect the constitution and to produce a little anarchy. Thank you.
Okay, so thank you very much, ma'am. I think apart from the wealth of knowledge, you were able to give a glimpse of the last 10 years of UID in 60 minutes, so we couldn't really ask for more. So we'll open the floor for questions now. People who want to ask questions can raise their hands. And we have a couple of mics over there.
I know I didn't give all the answers, so there must be...
Yeah, there will be a lot of questions. Okay, so we'll start with Ashwin.
Sorry, these. Okay. Hello. Cool. Okay, so the largest problem with the Aadhaar and with projects of this nature is the fact that there's not enough scientific approach to it, right? It's that when you do something like the Aadhaar, you need to take surveys and see the success rate over a large number of people, which the government clearly hasn't done. And it makes sense that they haven't. Because it's anti-political.
Okay, never mind.
It takes too long to really assess a lot of people. The largest problem is that it's very anti-political to really, it takes too long to really take these surveys, right? It takes too many years, and it leads to politicians being unwilling to really do this. How do you encourage the scientific approach within a democracy?
No further questions? Oh, yeah. No, you can just...
It's easier for me to see them. No, it's okay, sir. I just find it easier if I can see everybody. That's right. The question that you ask is a question that shouldn't be answered directly. I'll start with saying this, that first of all, there was no feasibility study for this at all. And till date, you don't have it. The second thing is that it's not like I wouldn't call them studies, but different reports did not emerge on this. Those reports showed that there are problems. So it's not just about spending too much time doing studies, and then in the meantime, the technology has changed. So that's the thing. The third is that here you found a complete disconnect between the corporate interest, which was pushing the project, and saying that we can deliver it for you. So, the TAGUP report becomes important for this reason, that the TAGUP report said government has a lot of data which it has no ability to manage. So the government must hand over all the data that it has to private companies, which will be set up for that purpose, where the government can have between 26 and 49% interest. Not more than that. And the logic was that government has no ability to deal with it. So this is a complete, and the government was also told there are certain things that it can use it for. Now, if such a thing exists, and if we know what kind of uses you're going to put it to, at least that should be made public. Now, you can't, because you're innovating. You don't know where it will lead. Today I'm saying, let me first collect all of your data. Tomorrow I'll make it into a platform. Then I'll tell all the business fellows to come and build businesses on it. In the meantime, the government can issue 134 notifications saying that it can be in every database, because we use anarchy as an excuse. We say there are too many people, and therefore we need a system that will capture everyone at one shot. Right? So if you are actually going to affect 1.28 billion people, and you do it without, in the beginning, having conducted any kind of study, and then you do studies which show there are problems, and you ignore them saying, okay, we'll deal with it as it comes along, then your question should actually be a different one. Not this. Not, won't it take too long, should they really wait? It is that they did do things which showed that there are problems. Then why did they continue with it when you know it will affect such a large number of people? No?
I think my question was a bit lost.
Oh, okay.
My question was more, how do you encourage the government to do this? As in...
Okay. How do you encourage the government to do the studies? Yeah, it's very difficult. And the reason it's difficult, I'll tell you, is because we don't have the same countervailing power. We don't have the countervailing power that we need over the corporate. What the past 25 years has done since liberalization and privatization is that the relationship between the state and the corporate interest has changed. So if you look even recently, there's the ease of doing business is much more important than ensuring that people's lands are not taken away, or that that they have full procedural and substantive rights. So in a situation like that, how do you get them to do it? You do it through democratic means, which means that you're not doing it through telling them what to do because they won't listen, but you tell them through means which they cannot not hear anymore. So you produce evidence, you protest, you resist, you let the whole country know that there is a problem. And if it's, my thing is, if a country of people become a country of sheep, then that's our fate. And we have to fight that fate. I'm not fatalistic in that, oh, that's my fate, I'm going to sit down. I'm saying that's what we are creating for ourselves. So we have to then fight that. But I don't think we've been like that. We've actually learned how to push back. And we've learned to watch. The advantage in the UID project has been, it could have gone in one of two ways. The technology could actually have been very good, in which case our trouble would have been greater. The technology is a load of you-know-what. So that's been a huge help. See, the thing is that this is a project that got marketed, but it didn't have content, it didn't have substance. So you can't say after 10 years, after collecting all my data, that what we've done is we have allowed payment wallets to do eKYC easily. I mean, really? Yeah?
Yeah, hi ma'am. My name is Rahul. So I have more than one question, so if I exceed the threshold, stop me. So firstly, as far as the privacy decision is concerned and its implications on UID litigation, do you think the exception of legitimate restrictions, if I'm not
Yeah.
wrong, that's the wording which they use there, would have some kind of impact on the decision which is awaited here? The second question is with respect to how the process of collection and authentication is done. Now, if I'm not wrong, there are certain private entities also involved in the outsourcing of technological work. Now, giving it to the government is bad, but it being passed on to other private entities, if I'm not wrong, is worse. Do you think that could play a role as far as this litigation is concerned? And the third question is, what is, in your view, a constitutionally compliant or an ideal use of instruments such as an Aadhaar card? Is the concept of an Aadhaar card itself something which is questionable, or is it that it's just being used in an incorrect manner in the sense that it's being made mandatory for welfare services? The fourth one, the fourth question is. So the fourth
Yeah.
question is with respect to what you referred the Delhi High Court judgment. So I was not aware of that Delhi High Court judgment. The question generally is that, as I understand, the position might have changed. Is that people who have an Aadhaar card need to link it? Those who don't have, are free. So what exactly is the rationale of even people who have it making it mandatory? Like, where exactly does this distinction come from?
Okay, so I'll start with the last. When the case was being heard on the income tax and PAN last year, it was done there were all kinds of things in that decision is not a very good decision. But what did happen as part of the discussion of the argument was that the court said, listen, the privacy case is already before a larger bench. We can't decide it. So the lawyers took a calculated risk and said that, okay, we'll argue the rest of it because there is enough on the rest of it. One of those was that this biometrics belongs to me and nobody else can take it away like it's their property. So the court at the end of the day said that, listen, this also sounds like the privacy argument. But anyway, this much we will concede that if people have already given their biometrics to the state, then we can ask them to put their number into this because you've already parted with your privacy. But if you've not already parted with it, then we will make an exception of you in relation to linking it with the PAN card. Now, of course, the income tax department deliberately uses that to say, oh, they only said PAN card, they didn't say income tax returns. So for returns you have to file, you have to give your number, which is making nonsense out of the judgment. So the logic was this, that if you've already compromised your privacy, continue doing more of it. That's why I say that it was not a very good decision. I mean, it was a decision where you could see that the court wanted to uphold 139A, and in wanting to do that, they had to make an exception because it's also an extraordinary decision when they say, oh, you see, in any case, the privacy judgment has not been done yet. That hearing still has to happen. Till that judgment comes, we can compromise your privacy. It actually made no sense. The balance of convenience was, by my understanding at least, and a lot of people say this, in the interests of the people and not in putting everything into the database while the case was still pending. So that was the logic, but yeah. So the second and third and fourth and fifth, I'll just take. Is the UID, you asked, is the Aadhaar card itself a problem? So it's a useful starting point for me. When the project started, it was clarified to us that there is no card. It is a number attached to a biometric. So if your biometric doesn't work, your number doesn't exist as yours. Which means that you don't have an ID under this system if your biometric doesn't work. Which is why today they say, oh, if there are some poor people, they're going to get their food rations and the biometric doesn't work. We have told the local authorities that they should not deny them food because their biometric doesn't work. They're not saying, oh, it should work, how is it not working? So there is this idea that this can't operate as an identity, biometrics is not going to help in it, but the number should be everywhere. That's why I'm saying that over a period of time we learned that it was about a unique number and not about uniqueness through biometrics. Everybody had to be identifiable as a number. You know, I belong to that era where Tamil cinema used to be whatever, and when we would walk out of theaters, one of the things was every film will have a cop, one constable, somebody, and there will be one big cop who will walk and say, hey, 203. So they'll call them only by that number, So all of us have to be identifiable by that number. Except that we'll have 12 digits, so it's difficult to call like that. So there is no card. That card is a myth that has been created because have you seen your cards? Does it have anybody verifying it? Have you seen your driving license? Yeah? Somebody signs and says that I have verified. Nobody does that here. Can you just download your driving license from some website? You can do this here. Can you change any information you want by just getting onto a website? And this is complete nonsense. But it passes off the way it does because it has the power of the state behind it. Not legality, not technology, but the power of the state. So there is no such thing as the Aadhaar card. And my problem with this project is first, primarily, that you are databasing a whole population. When they say proportionality, what can be proportional to allowing a whole population to be databased and make us all vulnerable to hacking and attacks? What sense does it make? And it's not only a personal problem, it's a national problem. If your whole population is out there, and then they'll say, oh, but what will they use it for? I can think of multiple uses, but I need to write many science fiction books before I do that, because I find every meeting I go to, they're telling me, oh, we thought this was only science fiction, but it's happening now. Except it's happening in a warped kind of way. The third you said about private entities making a difference. Actually, it's fascinating because, in this project, during the hearing in the court was really expecting that there will be some answers from the government and from the CEO of the UIDAI, and I think I saw disappointment in them. Because at one part of the proceedings, you had one of the judges asking the CEO of the UIDAI, he said, the petitioners had been saying that the government had said in Parliament that 49,000 enrollers, these are all private entities who after 3 days are given a certificate by the UIDAI that they can be enrollers. 49,000 enrollers had been blacklisted in this process. So the courts asked the CEO, what were they blacklisted for? And he blithely said, corruption. Now this was a project that was supposed to stop corruption. So if the project is itself based on corruption, then the court was a little taken aback. Then he went on further to say, not just corruption, because there is what do you mean by corruption? They said, they are not supposed to collect money for enrolling people, but they collected money. So then when we found out, we blacklisted them. But that's not all. They also deliberately fudged the data of people as they were entering it, so that they'll have to come back again only to harass people. This is what he said, just to harass the people. Now, how on earth can a project like this be the project that is stopping corruption and stopping harassment of a population? So the idea that you had, this is a classic thing, and we have to hear Mr. Nilekani carefully to understand where it goes. In his book, Rebooting India, he says that government, that's his imagination, and he's kind of, brought that imagination into practice. He says government is a series of startups. All the Prime Minister needs to do is to identify a problem, pick a person to take care of it, who will find another 10 people. So all it takes for this country, for all the problems of this country to be solved is 100 people. What are we all doing? We can all go home and have happy maja time. This is the imagination that's driving it, where you start up and outsource. That's the kind of government that we are seeing coming in place. Now I remember what I was going to say about the Bessel contract. It's that the last that I heard, I don't know what's happened since, no company had applied for this contract. So some reporter went to one of those companies which was likely to have applied for this and said, why did you not respond to this tender? And the reporter says that what he was told was that, if we apply now and we get the contract, then we have to change our whole business model, because we'll have to become much bigger, we'll have to invest a lot in it and all of that. And then if somebody goes and makes some legality or privacy comes into question, then the whole thing will come a cropper and we lose. So there is to me, that held a very, very important lesson. It's that when you challenge it, whatever may happen in the court, there are all kinds of implications in how other people see their own role in projects of this kind. And that is an important lesson that I think this challenge to the project has already rendered. That's where the private companies come in. And I'm sorry, I wrote privacy, legitimate state interest. Yeah. Yeah, will it make a difference? I'm going to be kite flying when I do this. But I will say this, that I really think the court is going to find it very difficult to say that it is legitimate state interest to do the range of things that they've been attempting to do. What I'm curious to see, I'm not even going to try and anticipate the judgment, but what I'm curious to see is how the court deals with the idea that you have a whole population having been coerced illegally and against court orders, calling it voluntary. So even today they'll promote it saying that, oh, but so many people have come voluntarily onto this database, and that's how it's promoted everywhere. And where nobody talks about the illegality and talks about it as if a state managed to achieve this. How did they manage to achieve it? So I'm very curious to see how the court views this relationship between the state and itself in terms of what the court is supposed to do in protecting the rights of people. I'm really curious to see if they deal with it at all, and if they deal with it, how they deal with it. To my mind, a database that is created with so much illegality, that itself is a reason why it should go. Then another reason that it should go, it's an unaudited database till today, and I believe that the unaudited nature of the database is because if you actually audit it, you'll find the problems that there are with that database. And so nobody is allowed to see it, especially the biometric database. They've just completely shut it from any kind of outsider's view. Even you can't see your own biometrics in that system because they are protecting your privacy. That's the project. Yeah?
Good evening, ma'am. This is Nishtha. Recently, the UIDAI ruled that authorities like NCRB won't have access to Aadhaar. So, keeping the negatives of Aadhaar aside, my question is, why can't organizations like NCRB or police be given limited access to Aadhaar because it will help in identifying crimes or the unidentified bodies?
So this actually has two separate things. Why did the UIDAI say no to giving it to NCRB? There is a story to this too, which is the CBI versus UIDAI versus CBI story, which is that in Goa there was a crime of a child, a 7-year-old was raped, and it was like one of those gruesome crimes. The police didn't do a great job of it, so the CBI came in. The CBI said they found a random palm print on the wall of the toilet where this crime occurred. They said, we don't know whether it is linked to the crime or not, but we would like to check it. So they went to a judicial magistrate and got an order saying that the UIDAI should share with them the biometric database of all the people who have enrolled in Goa. The magistrate said, yeah, you should do it because it will help solve the crime, just like you did. And then the UIDAI went running to the High Court and said, oh, we can't do this. And why? And you must remember that by this time, the case was on in the Supreme Court where the petitioners were saying that our privacy right is violated, and the UIDAI was saying there is no violation of privacy right. So in the Bombay High Court, they went and said, oh, we have to protect the privacy interest of the people who've enrolled with us, so we can't give this information. They also said that the way we collect this information, it can't be used for forensics. Because we say all the fingers, thumbs, iris, only then we'll be able to do any kind of matching, so we can't do this. To which the Bombay High Court said, the Forensic Science Laboratory director says that he'll appoint someone to check if it can happen. So by then they were not asking for the full database. They just wanted 3 sets of fingerprints to be checked against the database. And that's what the Bombay High Court ordered. So immediately the UIDAI went running to the Supreme Court. In the Supreme Court, the judges had a little bit of a laugh because the case was before them where the UIDAI was saying there is no privacy problem. But they were coming now and saying we are protecting the privacy interest. So they said, haha, privacy. And then they said, okay, anyway, you don't have to give the biometric, don't share the biometrics without individual whatever. Then in 2015, August, when the order was passed, there was one more little thing that was slipped in which said that if any court requires it for criminal investigation, then you must share all the information. This happened on August 11th. August 13th, we checked their website and we found that there was one thing called the UBCC research, which had been inserted into it. Maybe it was there from before. I don't think so, but anyway, we noticed it then, and we regularly monitor the website. That UBCC stands for UIDAI Biometric Center of Competence. Okay? And they were saying we are going to do research now to find out how to make biometrics work for a national ID. Why? Because the nature and diversity of India's population makes biometrics a challenge. I'm sorry, I've said it so many times, it just rolls out. It's so crazy. You have already collected it. It's 2015. 5 years you've collected this information. Now you say that, it's a challenge for all these people, so we are now going to do research. Then in 2016, they passed the law in which they say we will not give this information, not to a court, not even to you. And after that, you don't see the UBCC in the English section. You find it in other websites with Gujarati, Tamil, all that, but you don't find it in the English thing. They've pulled it out. So we look to see how much money got spent on this UBCC, that system. And we find it is the amount that was allotted to it is 0, and the amount that was spent on it is 0. So no research actually was done at all after admitting that there is a problem with this. So when you say that they don't want to share it with the NCR, National Crimes Record Bureau, it's because they know the nature of their database. Now, whether I would want them to share it otherwise, that's a different story. I actually don't think the database should exist, so there's no question of sharing it. But I really have a problem with treating a whole population as a potential pool of criminals. What are we reducing ourselves to? Every place we go, we've become documentary citizens. We have to prove our documents every time. We've become reporting citizens. We've become people who have to go regularly and say, I did not do wrong, I did not commit crime, please, I want to give you money, let me come and reveal myself to you to pay my... what is this? So this reimagining that has happened of the people as just a market and as product, that's what we are fighting. So whether it's NCRB or anybody else, we wouldn't want anyone because this shouldn't even exist. Yeah.
Good evening, ma'am. This is Tejas here.
I can hear you. No, it's you use it.
Clearly, in this case, the executive has used a lot of powers. The power has been concentrated in the executive's hand, and the parliament has not even, there is no significant role of the parliament in this whole case. So, it in a way questions the credibility of the parliament. So, how do you think this issue could be addressed? And in the whole case, how did the parliamentary standing committee report help you in the case? I would like to know about that.
So I'm not very sure. I agree with you that it's been in the hands of the executive. I don't think so at all, because the executive actually has had no role in this. It's been done entirely by the UIDAI, which has been treated as an entity on its own, and it was done under. They were located under the Planning Commission. And when you read the strategy overview document, and then you read the tag-up report, you realize that the UIDAI was also was expected to become a national information utility, which means it was expected to become a private company. It's just that all this intervention that happened did not allow that to happen, allow it to come. So I'm not very sure about that. But on Parliament, see, Parliament has not been altogether out of this. Parliament has actually played some role. And I may not fully agree with you that it's had no place at all. For instance, when you think of the Parliamentary Standing Committee, it had 31 members, and I think one person dissented from the main report. One person said, it's okay, we can try it. And one person said, I agree with everything other than the last paragraph, and that's because he had had a fight with a member of the other party that morning. So you can't agree with all the conclusions of the report and then say only that last paragraph, that was peak. That had nothing to do with the report itself. Across party lines. Parliamentary standing committees work across party lines, and they work in their individual capacities, they don't work by party whip. So that all of them agreed and that they applied their minds and that they produced this tells me that, they didn't shirk what they needed to do. When the money bill was introduced, prior to the money bill being introduced, they had to take back, they had to withdraw the bill that was there in the Rajya Sabha. So when they went there, the questioning started even then. They said, will you be introducing another bill which we will debate? What will be the process? It's the current dispensation that said that we are not going to allow you to debate it. And if you look, one of the persons who's gone, more than one person has gone, more than one parliamentarian has gone to the court saying that, okay, if we are not going to be allowed to function as the Rajya Sabha there, that is unconstitutional and we are going to challenge it in court. So I'm not sure that they have not, we can say that they could have done much more, done somewhat less, but their role has been important in this. It's not been inconsiderable and it's been important. And every time, when people say, oh, these politicians, oh, these parliament, I don't agree at all. I actually think the amount, for many of them, having to read like 30 bills and 40 bills, like 140 bills sometimes they have to read. This time, I don't know how many are being introduced. It's given to them 2 days before it's going to be introduced. They have to quickly understand what it is and then they have to have their grand statesman-like arguments on that. It's not even practical. And what are we doing to help them with it? So it becomes our business to follow what is going to be introduced in Parliament and whatever each of us has as our expertise to contribute to parliamentarians on that. And I can tell you they listen. They want to know. There are many parliamentarians who are asking for help. That's why the LAMP project, for instance, was very helpful because young people went and actually helped them with all those documents. But young people will do their bit and others need to do their bit. I think there's a lot of work if you want a parliamentary democracy to function, to think that when you have voted, your job is done. And now it is somebody else's job and I'm just going to sit here and slam them. It doesn't work like that. We have to work at it. I can never, when the temptation comes, I can't resist it. So, to quote Kannabiran, he would tell us that, he's written in his book too, that it's an arduous journey from being a slave to becoming a subject, and from being a subject to becoming a citizen. And then what follows from that is that because you've become a citizen, it doesn't mean you'll have it forever. You have to work at retaining it. So that work, if we don't do, I think we need to question ourselves a little bit too in that.
So
Yeah.
we'll take the last set of questions. There's
Yeah.
Benji, Parika, Achman. Anyone else?
Here, he had his hand up.
Okay, and Satyen. Yeah, that's good. There might be some time for informal
Whenever
discussion.
you want.
Hi. So, I believe in December 2016, around there was the report on fintech by the RBI, I believe, where they have a short mention of regulatory sandboxes. And this February also, there have been multiple reports around the same, and different governments across the world have looked at this form of a solution to address emerging technologies, because it is without a doubt that this is something that must be addressed. You can't ignore it. The government must look at it. But
One second, must look at what?
emerging technologies, and they can't just say we are going to ignore this is not going to affect us. Like, they have to tackle the issue somehow or the other.
Right.
But what I'm thinking is, when we have stuff like where the government does not allow itself to be challenged in the sense of, let's say, RTIs, or doesn't have a good bug bounty system like Hack the Pentagon, or like anytime someone actually shows vulnerabilities in its databases, they just fine them or they jail them or stuff like that. The question is, no matter how good of a system you actually have initially, let's even assume they have, which they clearly don't, the culture that's there, the political culture that's there of, I am in power now, don't question me. Like, especially in technology, like, that's not possible. Like, you have to keep assessing yourself, right? So how will this issue be addressed when the political will is so against self-questioning?
I don't know that the political culture is so against our questioning it, in the sense that I know that right now we feel like our speech cannot be as free as otherwise. My real problem is that when there are government committees, and those committees only have people in them whose business will grow depending upon what that committee produces, I think they are not even committees. They are just interest groups who are producing reports. When I saw the Vattel Committee report of December 2016 that you were saying, that's what I felt. I felt like here you have a range of fintech people who are sitting there and writing a report on what the government needs to do to help their business. Now, that's not the job of any government committee. You have to have a balance. And interestingly, when they begin, they say that the only dissenting member was the banking representative. Then they never tell you what he dissented against, or what that position was. They just discard it after that, and they carry on with what they want. So I think there is a logic to demanding process. But sometimes we get lost in the process and then we forget what the substantive issue is. So the idea that we need to know the substantive issue, we need to understand it, we need to, track it and tackle it and become counter forces to the kind of forces that exist otherwise, has become even more important with technology than before it. The way technology, the technology debate works is that technology people don't know what they are going to be doing with it tomorrow. So they say, if I don't know, what do you know? So what are you going to make a law on? Because technology will always be ahead of the law. And my thing is that basic principles and constitutional norms, we have this discussion very often when we have meetings and it becomes like, oh, what do you know? The techies who come from Bangalore will say, Delhi doesn't understand technology. And we are constantly telling them, yeah, but Bangalore doesn't understand the constitution. So you have to learn to talk to each other. Yesterday I heard something though which was kind of disturbing, because there was this, like I said, a very well-meaning person who was saying that this country has many ambitions. There is electronic vision, digital vision, envisioning that we are doing, that we will become the greatest in this, that, and the other. So we'll be the digital empire. But the fact is that we don't have enough technology, people in technology who can produce that next generation. We just don't have them. And it's perhaps true that many people in Silicon Valley or wherever else are persons of Indian origin who are sitting there and doing it. But they're doing it there. They are doing it for the Googles and Amazons and whoever else you have. And yet, the kind of programs we are trying to put in place is going to require an intensive number of people who are going to be technologically very, very advanced. We don't have them. The other thing that was said was that, all these systems need impeccable encryption. We don't have it. But we'll carry on anyway because something may catch up. Now, the thing about technology is they'll always tell you technology is neutral. Technology is neither good nor bad. Technology is neutral. And you only have to think about, using it and using it well and whatever. So the abuser is always only the technology, the person who is abusing it and by using technology. But the fact is that there is no such thing as just technology. Technology is used. Technology has a controller. Technology has someone who's creating the programs, and there is a logic that they follow in creating that program. One of the things that's disturbed me immensely in this period is that the extent to which the technology people want to control the systems that are going to get set in place when they don't even know the people nor the problems for which they are supposed to be addressing. So one of the most disturbing interviews that I've seen in recent times, and you have to watch a lot of that to know what is being said about social credit systems and use of AI and trickle up and all the rest of it. One of the most disturbing was Veer Sanghvi interviewing Rahul Mathan, but it's not Rahul Mathan who is the problem, and Nandan Nilekani. 3 times in that interview, he asks him, so in that process, a young child dies because the UID number doesn't work for them. Doesn't it disturb you? And then he answers saying, I don't want to get into debate on all that. Nobody is debating it. It's a question. It's asked a second time and he doesn't answer. And the third time, he doesn't answer again. Because he's saying, actually, you can't look at anecdotal information. You have to look at the kind of studies that get done. And what is the study that gets done? State of Aadhaar report, which is funded by OMIDR, which has an open agenda that they want to promote the UID. So, when you have people who are in charge of projects like this, who refuse to get sensitive, he even made Veer Sanghvi angry. Because you have Veer Sanghvi saying it, because when they began, Mr. Nilekani said, I was a good guy, then I became a bad guy, now I'm a good guy again. So Veer Sanghvi asks him, so what makes you a good guy again, right at the end, after all this has happened? And he says, because people have realized that, there's Cambridge Analytica, there are all these other problems, so UID is not really the problem at all. Then V. Sangvi says, okay, that's about the system, but what makes you a good guy? And then he ends up telling him, you're a good guy in your own mind. I too did laugh, but it also chilled me, I must confess. To think that this can actually be the source from where answers are coming for the problems of poverty. It's scary. Oh, no, that's not the word to end with. Say something else.
Hi, my name is Parika, ma'am. I think all of us here can agree that UID project has come so far that all of us have been coerced into linking it with some of the other services. My question is, how much of an impact is this going to have on the judgment? The knowledge that retraction of the project at this stage is going to affect services like banking and wallet that rely heavily on Aadhaar. So how is the court likely to rule on this issue?
Can you just take the last?
Yeah, sure.
Thank you for the talk, ma'am. I'm Ajman Shekhar from the second year. Databasing is a complex concept, the consequences of which are very difficult to explain to the populace. So how do we create, to the common man, ma'am? Yes. So how do we create a political conscience against databasing? Because until that is done, successive governments will be able to weave a similar rhetoric and will be able to pass acts like the aforementioned DNA Profiling Act. Thank you.
So do I start with that and move? Then I can... See, the thing is, how do we create a political consciousness? Actually, all this is supposed to be a process in creating that. And I don't mean talking here. I mean the 10 years of work where you go from place to place, you write about it, you get journalists to understand it, you go to various institutions and speak, you go into the courtroom and speak, multiple voices are speaking about it. Today, everybody knows that this is not something that can just be, you can't say, acha, theek hai, and carry on. That much everybody knows. Whether they know what the problem is with, and some people even say, theek hai, yaar, I mean, I've taken so much rubbish in my life, I'll take this also. So there are people who do say that. In fact, when it began, people would tell me, kuch nahi hoga. This government will never achieve anything. We will keep telling them, don't depend on inefficiency to protect your rights. So, it's a process of training ourselves to think and of sharing that knowledge. The one difficulty that I found in this project, which arises also from the kind of question that you asked, is that when people were having a problem on PDS and on NREGA and whatever, and pensions, social security pensions, maybe it came, you had one item in the paper here and there about something. People didn't notice because it didn't affect me. Then it came to banks and it came to IT and to mobile phone and everybody woke up. Then the court said, okay, not mandatory for these. Then everybody went back into a hole. I feel, and this is something that I'm increasingly feeling, and as I grow older, I see a vaster canvas and I can see it more clearly, I think. I think one of the most important words in the Constitution, to preserve the Constitution and to protect it, is fraternity. If you can't care for everybody's rights, your rights won't remain. So if we pull back the moment somebody else's right is affected and not mine, your right is going to be affected. You can't run away from it because you gave up, you didn't care when it happened to somebody else. So that, even today, I know people who have asked me, and it's some shocking cases where people have said, people died? It's been in the papers, but if you notice, even when you read the paper, when I read the paper, I don't even know that the World Cup is on because I don't read the sports page. I look, I see if anything is said about, at one time, people in India could not go to Patiala for that, for training unless they gave the UID number. So I learned to look at the sports page for that. I don't notice anything else. So I'm saying, and therefore it slips their mind that the poor are dying somewhere. I think if we don't, invigorate the value of fraternity, we may find ourselves in a bad place. We really need to work on that. And so that's one. And it was something about how much will it affect banks and what will happen if the project is actually struck down. The idea in this project was to quickly get everyone onto the database, quickly make it ubiquitous, and quickly change systems so that it will depend on this. That actually hasn't happened. You may have put your number into the bank, but it's your bank account number that you're working with. The number, Mr. Nilekani worked with the NPCI to get the money to move from UID number to UID number. And they were doing that when the Airtel debacle happened. When Airtel took consent supposedly for linking your mobile number with your UID number and ended up opening also a bank account in your name which you knew nothing about, and subsidy monies kept going there which you knew nothing about. So after that there has been some caution. We don't know, since there is no disclosure on any of this, we don't know why they have pulled back, but now banks have been told that monies will not, by NPCI, that monies will not be moved to a UID number. So that system has already stopped because it is, so that's why I said in the beginning that if it had been a system that worked, we would have had to deal with a different set of issues. This is a system that is crumbling already. So I don't know that that anxiety really afflicts me. I don't find that a big issue because not only have they not managed to make systems move into the UID regime and drop everything else, the UID thing itself is crumbling. So I think we need to see what that means. When they say in PDS that when you go, if the fingerprint doesn't work, then local person must give. That tells you that that system has already stopped working for many people, right? So that anxiety, honestly, I don't think we need to carry home with us. We'll drop that. But if they do say, if the court does say that this is not a good system, and they say that it can be at best voluntary, which I don't think they should say because we know now that if you say voluntary, they will illegally make it mandatory and every time you can't keep going back to court. If they do say that, then they have to build in an opt-out system. Because like you said, almost everybody I know has got into it because only two people that I know, they are conscientious, disciplined, what we call in Tamil, shamattu people. Good girl, like that. So they got there right in 2010, soon after it began in Bangalore. They got an appointment for 2 a.m. There are people who sleep at 9 and wake up at 4. They went for a 2 a.m. enrollment. And then the articles started appearing. Since then, they've been wanting to opt out. So even those who went in voluntarily, once they saw what it was about, many of them don't want to be part of the system. So there will be a lot of work to do after the judgment. It doesn't end with the judgment. It begins. There's another beginning with the judgment. Thank you.
I must thank ma'am for taking out time to come down to Nalsa. Also, so apart from giving important lessons on UID, I think ma'am was also successful to give us important lessons on why and how to become a good lawyer. So that is something which all of us should keep in mind. Okay, thank you.